All right. Good afternoon. I'm Jack McMorrow. I am co-chair of the Beverly Hills Bar Association Family Law Section. Thank you for joining us today. The Family Law Section is sponsored by White Zuckerman Warzowski Luna Hunt LLP, Lawyers Mutual Insurance Company, SoberLink, and Our Family Wizard. White Zuckerman, Warzowski, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Learn more at wzwlh.com. SoberLink provides objective, real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To help ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interests. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers. They're they offer special rates with competitive premiums for a wide variety of practice areas, including family law. Learn more at lawyersmutual.com. Our Family Wizard is a co-parenting platform designed to help families communicate more efficiently and more effectively, reduce conflict, and create reliable court admissible records. Features like AI, Tone Meter AI, shared calendars, expense tracking, and in-app audio and video calling help support compliance and better outcomes for families navigating custody matters. Having said that, I am delighted to introduce our speaker, Commissioner Patty Radican. She brings over 31 years of experience in the family law court system. She's a certified family law specialist. Her expertise spans alternative dispute resolution, child support, and spousal support matters. She has served as on the California Guideline Child Support Task Force, the Department of Child Support Services Guideline Child Support Calculator Task Force, and the Superior Court Family Law Committee, and the CJER Family Law Curriculum Committee. She created the curriculum for the the primary assignment training for AB 1058 child support commissioners and has lectured extensively on family law across California. I'm so happy to have you here. Let's get started.
Thank you, Jack, for your kind words. I appreciate those. Good afternoon, everyone. Thank you for taking time out of your busy schedule to be here with us today. I would like to take a moment to thank Suzanne Jimenez for her assistance through this three-part series. Her hard work, organization, and dedication have been instrumental in making these programs possible. I'm truly grateful for her efforts. In this session, which is part 3 of a 3-part program, we will be discussing spousal support modification, establishing arrears, and enforcement issues. Hopefully, you'll walk away with some tools to pursue a modification of spousal support for your client and enforce the orders that you get. Let me see. Okay. So, what comes first? A modification of spousal support begins with 3 questions. What facts supported the existing order? So we're looking at the last order.
Radican, I'm sorry to interrupt. It looks like we can't see the content of your screen right now.
Oh, I don't know why. Let me see. Let me try again. Can you see now?
It's loading. Yes, we can see it now.
Okay,
Perfect.
sorry about that. Okay, so the modification begins with 3 questions that you should ask yourself. What facts supported the existing order or judgment? What has changed? And does the change justify a different order? If you cannot answer these 3 questions, modification will likely fail. One of the most important concepts in the support modification is that every case begins. So when you're talking about what facts were the support, in the prior order, what were the parties' incomes? What findings did the court make, hopefully, or what findings were included in your stipulation? We talked in the last seminar about how important it was to include the Family Code Section 4320 factors each and every time you either enter a stipulation or make sure that the court makes those findings for you. You can't prove that circumstances have changed unless you first know what circumstances existed. So California law requires a material change of circumstance. Change might be an increase or decrease in income, retirement, a significant change in the health of one of the parties, a change in the supported spouse's needs, or some other event that was not anticipated when the prior order was entered. Simply disagreeing with the original order or the length of time is not usually going to get you a modification of the support. The key here is that the change of circumstances was not anticipated at the time the last order or stipulation was entered into. On the third question, not every change is legally sufficient to justify a modification. The court must determine whether the new circumstances warrant an increase or decrease or termination of the order. If you remember nothing else about spousal support modification, remember these 3 questions. They provide a roadmap for every successful modification case. Without understanding what the original order is and identifying material change of circumstance, and then demonstrating why that change justifies a different result, the request for modification will certainly fail. Okay, your statutory authority for spouse support modification is Family Code Section 3651. Retroactivity is dealt with in 3653. Of course, the 4320 factors. Then we deal with 4323, which is cohabitation. 4330 is the duration, the marital standard of living. The 4336 deals with the long-term marriage, and 4337 deals with death or remarriage. We're not talking about modification at that point. We're talking about termination. So the threshold issues that you need to deal with when you're seeking a modification for your client is make sure you obtain a copy of all the orders. The original order, if there's any modification order, make sure you read those carefully. Determine whether or not the court has jurisdiction to modify the support. Was there a previous non-modifiable support order, which you wouldn't get from the court because the court doesn't have the authority to do that, but if it's a stipulation, make sure that you're not going to end up in court with an order that can't be modified. You consider the length of the marriage, the short-term marriage versus long-term marriage, and that's not in concrete. Whether or not a Gavron admonition was given. And so if you're seeking a modification of support based upon the payee's failure to become self-supporting, you may have to make sure the Gavron admonition was given because the case law says the court can't terminate unless that happened. If you're dealing with a Richmond step-down order, you have to consider whether or not the expectations that were outlined in the Richmond step-down order have been met. If you have a failure of expectation, which if you're representing the party seeking the modification of the Richmond step-down, they should know, hopefully, whether their spouse has had any unrealized expectations. I'll give you an example. I had a case where I negotiated a step down, and my client was going to be a teacher, and she couldn't get the classes she wanted, and she broke her ankle and couldn't attend class. So I was successful in convincing the court that there was a failure of expectation and got her order continued. make sure that there's not a termination date fixed in the order, because sometimes judges look at those kind of orders and think that somehow it's non-modifiable, even though it doesn't say it's non-modifiable. So that's something to consider and spend some time trying to overcome if you have that case. So material change of circumstance. Identify what the order was. And do a chart. You know, here's the factors now, here's the factors or then, and here's the factors now. If we're talking about an increase in income for the payor spouse, consider in re marriage of Hofmeister and the Hofmeister 2 case, because what it says is that an increase in income for the payor spouse is usually not a justification for an increase in support, unless the original order stated that it did not meet the needs under the marital standard of living. Has there been an increase in expenses? And what you need to look at there is if the payee spouse increased their expenses intentionally, that goes back to analyzing it under the marital standard of living. A reduction in income alone does not necessarily justify a modification if the reduction of income was voluntary and not made in good faith. You do have that one case where the gentleman wanted to go into the to become a priest, and they said that that was acceptable. The other types of changes you might expect are the supported party obtained employment or increased their earning capacity, a completion of education or training, cohabitation, new inheritance by the payee spouse, a sale or acquisition of assets, assuming they weren't part of the original order, a vocational evaluation that you had done at the time of the order and the party has not met the expectation under the vocational order, a reduction in earning capacity by the payor, or health changes. So next we're going to deal with the 4320 factors. A lot of judgments, orders, not judgments, but stipulations that I found had no 4320 factors in them at all. They just had the numbers, what the incomes were. And so if you run into a situation where you have a client who wants a modification on that, you should identify what the factors were at the time they entered into that stipulation, or if the judge fails to do the 4320 and no one objected, you should do the same thing. What are the factors then and what are the factors now? Because the judge can't determine that without knowing both of those things. Cohabitation issues. A common ground for seeking a modification is cohabitation by the supported spouse under Family Code Section 4323. That is, there's a rebuttable presumption of decreased need for support. However, I have seen judgments and stipulations that said cohabitation is a terminating event. So the order is going to control on the cohabitation issue. It does not automatically terminate or reduce support. It shifts the burden to the supported spouse to show that despite the cohabitation, his or her financial needs have not actually decreased. The first question that you should ask yourself, however, is when did the cohabitation begin? Because if it started after the order, it is a change of circumstance. If the supported spouse was already cohabiting when the prior order was entered, you then have to show a different material change of circumstance since the prior order, such as have they bought a house together? Have they commingled their assets? Are they holding themselves out as married people? All of those things would be important to present those facts to the court on your motion to modify. So the next issue that comes up are retirement issues. Somebody retires. Is it going to be a material change in circumstance? First of all, is it of an age where they can retire? We all know that 65 is the magic age at this point in time, which I keep wondering why someone doesn't seek a good faith extension of that, because most people today who are in the realm of paying support are their maximum retirement age at Social Security is 67 years old. So I think that there's room to argue that that's what the court should adopt. But since I'm not litigating, I'm not going to take on that burden. The second consideration, was it a good faith retirement? Because you have these places where companies require that people retire at a certain age. Pilots, I think they're 55. Firemen, I think they're 55 or something like that. And then there's certain, there was an accounting firm that demands they retire at 60 or 61, I think. So you have to look at their contract or where they were working, and was it a mandatory retirement? The key takeaway is a retirement is not an automatic ticket to a reduced support order. It does signify a change of circumstance, but the person who's retiring needs to demonstrate that it was reasonable, in good faith, and it materially affected their ability to pay support. So one of the things that comes up is if the person gets a pension. And so if the pension was contemplated in the judgment and it was awarded to the party, the current case law says that absent what's called a white waiver, where that can't be used to calculate support, even though that was awarded as a property settlement, it is still available to pay support. So when you're negotiating that, you may want to consider trying to get a white waiver on everybody's portion of their retirements. If the party has passive income, that income is usually available to pay support, except I think if it wasn't part of the marital standard of living. Let's say that after the parties separated, the judgment was entered, the payer spouse got a huge inheritance from their family, and the income that they're getting from that inheritance is this passive income. The argument can be made that wasn't part of the marital standard of living and therefore should not be counted as the income available for support. So now we're going to head into enforcement of support orders. Every support order is an installment judgment, and it becomes a judgment when under Family Code Section 290 and 4502. Each unpaid installment is a money judgment and is immediately enforceable under 685.020B of the Code of Civil Procedure. It does not require a separate judgment before enforcement. It generally may not be modified retroactively once due. And think of every missed payment as creating an enforceable judgment for your client with interest. Calculating arrears. I've seen this done inappropriately more often than not. So one of the things that happens is when the court makes an initial support order on an RFO and grants it retroactively, for instance, let's say that the motion was filed in December 24th of a year, and the court grants retroactive support back to January 1st, but it's done at a hearing on April 1st. The support for January through March becomes a lump sum entry in the calculation of arrears. You don't start calculating January 1st because it was an unliquidated amount. The next issue that people run into trouble with calculating arrears is when there's a child and spousal support order and the payer makes partial payments. How do you credit those payments? It goes first to child support, ongoing child support, second, ongoing spousal support, third, principal child support arrears, fourth, principal spousal support arrears, then fifth to child support interest, then to spousal support interest. So that's how you apply payments when you're trying to do your calculation of arrears. Any other credits, you apply those. You have to explain them. Keep in mind you can't, I'm not dealing with child support today, but you can't credit the payment of something to support, to child support at least. Support judgments carry interest at 10%. And it is something that the court has no jurisdiction to reduce or eliminate. And that's CCP 685.010A1. So if you have a judge that's trying to, we're going to take questions at the end. So I will take any question you want, and I'll stay as long as anybody wants me to answer questions. So if a judge attempts to waive interest or reduce interest or arrears, the same thing applies. So when you're filing to enforce your arrears, you have to file an FL 420, which is a mandatory form. And there's an FL 421, that's an optional form, but you need some form of calculation of arrears, such as I use an executioner when I was in practice, or there's different programs that calculate arrears. My suggestion to you as a practice tip is to try to do your best to gather payment documentation from your client so that you can be sure that you're applying the payments that they receive properly. So there's equitable defenses to spousal support. Latches is not one of them. Latches is not available for child or spousal support. Equitable estoppel, waiver, accord and satisfaction, unclean hands, and domestic violence. So on domestic violence, one of the most interesting cases was in re marriage of Kelkar. It's a 2014 case, 229 Calap 4th 833. The court held that Family Code Section 4325 applied retroactively, and a stipulated judgment, it was actually a non-modifiable spousal support judgment, could be modified because husband agreed to the order without knowledge of 4325's limitation on spousal support. That's a good case to have if you're in that situation. Today, we're not talking about child support arrears, but one of the things you need to keep in mind is if you're going to attempt to compromise a child support arrears, you must include in the stipulation that there's a good faith dispute over the amount owed and a consideration for the compromise of the arrears. That case is in re marriage of M, and it's Sabine and Toshio, 2007, 153 Calap 4th, 1203. So enforcement remedies. The gold standard is the abstract of support judgment. Every support order that you get for your client should be followed up immediately with a recorded abstract of support judgment, because what that does is if the payer ever attempts, if is in arrears and ever attempts to buy or sell a house, your client will get paid their arrears from escrow, because the escrow will make a demand on the abstract. And so it's important to tell your clients that they'll have an abstract on file. If they change their address, they should notify or re-record the abstract so that the escrow company has a way to get a hold of them when the demand needs to be issued. We all know about income withholding orders, the wage assignments. A writ of execution is what you can get for a support arrears. Check with your local rules how they require that you do that. But here in San Diego, we issue a writ of execution that has a declaration regarding what the arrears are. If there's any concern about the amount of the arrears, it's probably a better practice to file an RFO and have the court set those arrears before you issue the writ. But if you are sure that you have the correct amount of arrears, you can just go through the writ of execution process, get the writ issued, go to the sheriff. You can execute on bank accounts, you can execute on wages. And one of the least used tools is a judgment debtor exam. A judgment debtor exam you can do every 120 days, and it makes the judgment creditor or the debtor life miserable. You bring them into court every 120 days and ask them questions about their personal life. And if you have a good faith belief that the judgment debtor has transferred property to a third party, you can ask for a judgment debtor exam of the third party also. Contempt. That could be a whole day seminar all by itself. But as a judicial officer, I didn't like contempt cases because most of the time people didn't know how to plead them properly. They misquoted the date of the order. They did something. And for a judge, they're very technical. They have to be 100% correct. You cannot make a mistake in pleading a contempt. It's like a criminal complaint. So if you do want to do a contempt, one of the things that I used to do as a lawyer is I would hire the guy that they appointed on all the contempts, and he usually won them all. I hired him to review my complaint, which did two things. One, my complaints were usually good, and two, it conflicted him out from representing the other party. So my suggestion is if you are going to file a contempt, find somebody like that, hire them, and have them review your complaint before you file it so that the judge doesn't dismiss it under Penal Code Section 1385. But, one of the things that I found that happened is when somebody got a contempt dismissed, it was basically like the person believed that the court had no power over them. So it oftentimes made it worse than better. So really consider whether that's the best option for you. Attorney's fees, this is often one of the things that everybody forgets on enforcement, is attorney's fees are available for enforcement. And one of the thoughts I had as a judge when I was dealing with somebody who had to chase their money is it comes out of the support. So I was usually more inclined, if I could, to order all the fees that the lawyer had, all the reasonable fees the lawyer had incurred to enforce that support, so that the party had the benefit of all of their support. So practice tips and takeaways. Audit the file first before you file an arrears motion. Never rely solely on your client's memory. Try to calculate your interest accurately. It's often substantial. Use all your remedies, your abstracts. First of all, do your abstract, do your wage assignment, do your writ, do your debtor exam. Get a lien, if possible, on real property if you know they have it. Request attorney's fees and document everything. Your accounting, your enforcement case is only as strong as your accounting, because if you file something and the other side presents a whole lot of evidence that they paid these arrears and your client loses credibility, that can hurt in an enforcement action. So, questions? Any questions?
It looks like we have quite a few questions within the Q&A
Okay.
so far. To start us off, one from Martha. Does the age of the Gavin order make a difference in a modification? Example, Gavin issued 18 months ago versus 5 years ago.
I think it does have some weight, but read the Shaughnessy case, because that's kind of a real good case about a Gavron warning. But a lot of it depends on the facts of the case. The longer the marriage, the less impact a Gavron's going to have early in the proceedings. But it really is very factually determinate for a judge, whether they're still kids, whether there's any type of disability, whether the party traveled, like you have a military spouse where the spouse went all over for their career. The Gavron's not going to have as much impact on that type of a case as it is on someone who, didn't do anything, didn't help the other party, didn't work, didn't, and there's no kids to consider. It's going to have more impact.
Right. Okay, so this is a little bit of a longer question here. Parties stipulated judgment recites there is no order for the payment of spousal support from one party to the other at the present time, end quote. Leaving the spousal support issue open and unresolved, retaining and reserving the court's jurisdiction for later adjudication. The judgment does not reference the parties or the court considered the Family Code Section 4320 factors into not resolving the spousal support issue in the decision to leave it for a later date, nor does it make any findings of marital standard of living post-judgment seeking a spousal support order. Is this an original order or a modification of a quote-unquote $0 previous order that requires a change of modification?
I think it would probably require a change of circumstance to be shown. From why was there no support in the judgment and why is it requested now? So I think I would, in an abundance of caution in your pleading your RFO to outline what factors existed at the time they agreed to just delay the issue with spousal. And a lot of it depends on what length of marriage it is. If it's let's say it's a 3-year marriage and the judgment was entered 3 years ago, I think you're out of luck. So you have to consider all of that, and just make your best educated guess at what your judge is going to do.
All right, I actually have someone here asking if you could go through the order of applying payments once again, if you could repeat
Sure.
that question a little bit.
Yes. When you get payments, you have arrears and you get partial payments. The payment goes first to ongoing child support, next to ongoing spousal support, next to child support arrears, spousal support arrears, child support interest, and spousal support interest. And that doesn't apply if you're in DCSS because there's a different thing going on over there about how you apply child support. So if you're in DCSS, you may want to read the code sections that deal with DCSS specifically. But they apply it for you, so you really don't need to worry about it.
Right. Let's see another one. Did you say that when a support order is made retroactive to the date of the filing, that you input it into the arrears calculation as a lump sum owing on the day the order is made? What is the authority for this?
I'm not sure, but that's because it's an unliquidated amount. And so unless you were to have the court issue prejudgment interest, because you don't have an order. So there's no order from January, the example I use, there's no order from January through April 1st. So April 1st would be your ongoing support, but those 3 months, they're now a liquidated sum, and that's why it goes in I'll see if I can find the authority for that, and I'll get it out.
All right, I have another question here. If a judge makes an order that the supported party has an obligation to become employed full-time by a certain date, can it be argued that it is likened to a Gavron warning?
I wouldn't rely on that. And we talked a little bit about Gavron last time. I think it's safer to if the judge were to make that order, I might follow it up with, Judge, could you please make a formal 4320L Gavron admonition to the party? You could argue it, and it's like a lot of questions that people ask in seminars where judges are speaking. It depends. It depends on the judge. The judge could interpret it that way. The judge could say no. What the appellate court would do with it, I'm not really sure. But the better practice would be to follow up and ask the judge to actually issue the Gavron.
All right, and let's see. Is it ever appropriate to grant a motion to dismiss an RFO regarding contempt based on alleged errors in calculation of arrears?
Well, you're not dealing with arrears in a contempt action. I mean, the amount, you're only dealing with whether or not they paid their support. So I don't think that's a basis to dismiss. If they failed to identify the order properly, yes, then that's a basis to dismiss. So let's say that the order said the support starts January 1st, 2026, and the contempt is filed for January, February, March, April, May, and they identify the order as February 1st, the contempt is dismissed. It's a, pled the defective pleading. But I don't think the amount of arrears comes into play, unless you're talking about dismissing an RFO because the arrears are incorrect. But I don't think a judge would do that either.
All right. If someone retired in good faith after paying spousal support for 10 years on a 20-year marriage and he's only relying on his retirement distributions to live, how much is he required to take for distributions if the other side is fighting the modification?
Well, I need a few more facts on that one. How old was he when he retired? Um, was there, um, are there any other factors that would justify modification, like failure to become self-supporting? Is the other party still capable of working? That's a real, I mean, that one is just without further facts, it'd be too hard to answer. If you want to give me more facts, I'll do my best.
So far, I've got 65 as the year, but I'll keep my eye on other submissions of information. Let's see. I have a question from Therese. And if in an RFO for spousal support arrears, does the legal interest start when the first payment is due, and is it compound interest?
No, it's simple interest, and the interest begins when the first payment is missed. So let's assume they had a payment due January 1st and they didn't pay it. Interest accrues from January 1st onward until it's paid in full. So when you're doing your, I like the executioner if you can get your hands on it. It's hard because CFLR doesn't do it anymore, but I have one on an old computer. But you just put in the day the order starts and the date you're calculating to, and it automatically calculates the interest from the first day of support being due.
Right. What defense does an obliger have who has never served with the RFO and does not know that a spousal support order existed, and W is now attempting, or is that wife, is now attempting to obtain a writ of execution 7 years later, and husband is retiring with a CalSTARS pension?
Okay. So if husband was never served, he has to file a motion with the court to quash the writ, first of all. And then outline, that he never got served with it. He had no idea of the order, and see what the judge does with that. So in San Diego, we had a situation where one of the process servers that was hired by the county, instead of serving people, just threw it in the trash. And then they got all these orders against them. There was a child support order, of course, but then what happened, actually read my case, in re marriage of Gorham, because it basically said wouldn't that there was no jurisdiction to make an order because there was no service. And so if the client could prove that he was never served with that, you probably stand a good chance of setting aside all of those arrears. So one of the things I would do on that is I would go to court and pull the proof of service and see what the proof of service says. So if you have a process server that signed a proof of service, you got to go find that process server and track down it, basically find out where that came from.
All right, so let's see. I do have some more facts regarding the retirement.
Okay.
So the client retired at 65. The other side was imputed minimum wage in the judgment. Other side claims can't work due to health issues because has an OHD. Oh, has a PhD and has authored several books, but claims not earning income.
Well, if it says nobody can be forced to work past 65 to pay support, so the client files a motion. He has a good faith retirement issue. So he files a motion saying, I want to terminate my support because I'm 65. I'm taking my pension. The other party has, it's been 10 years on a 20-year marriage. The other party hasn't taken reasonable steps to become self-supporting. And so one of the things that you want to look at in your discovery is this alleged disability that's now there. when did it happen? So can you prove the failure to take reasonable steps to become self-supporting before the disability? Those are the ways I would handle and target the the modification. Sounds reasonable to me, but I'm not your judge. So
Right, let's see. It looks like someone is asking regarding, would you mind restating the notice requirement for non-modifiable support orders?
notice for non-modifiable. What I was talking about is if you have a non-modifiable spousal support order, you shouldn't file a motion to modify it. Is that what you meant? Because there's no notice for, I mean, if you get somebody to agree to a non-modifiable support, they don't need notice. They just sign the stipulation.
Right.
The other thing I said was if you have a MSA or a judgment or a stipulation that has an order that says it's going to be paid, this is the amount of money, and it will terminate at that point in time. Let's say it's going to terminate 2 years from now. The judge may interpret, if you file before the 2 years, may interpret that, hey, you negotiated for this 2-year period of time. I'm not going to give you a modification if there's no change of circumstance.
Okay, so I don't see any other comments from that one. All right, for points and authorities in the RFO for arrears, I have the payer who hasn't asked ex-husband to pay the order in 5 years. Will that be an issue, or does she still get all what is owed?
Can you read the question again?
Yeah, for points and authorities in the RFO for arrears, I have the payer who hasn't asked XH to pay the order in 5 years. Will that be an issue, or does she still get what is owed?
She still gets what's owed. Unless you have, people modify orders outside, and these oral modifications, the alleged, he said, she said, he told me that, I didn't have to pay because he lost his job. He says, or she said, no, I just said you could delay it a month. They still owe the support arrears. So yeah, unless there's an oral modification that you can prove, then I think the person who is out of luck, they're going to have to pay the 5 years of support and the interest on it.
Right. It looks like we have a couple requests regarding, I guess, legal authority and also cases or citations.
Okay.
So this one is asking, will you please provide the legal authority for the order of applying payments, with that being CS, SS, CS principal, SS principal, etc.
Okay, I have that here. Let me give it to you. Hold on. Um, let me see where I have that. Thought I wrote it down. I'll find it. So they want the legal authority for applying payments.
Yes.
Okay. All right, I'll get that. Anything else they want?
Yeah, let's see. It looks like someone is asking for the case citation for the IRMO Gorham case.
Quorum. Okay, I'll get you that too.
And let's see. I think that's it for that. Just regular questions again.
Okay.
All right. So someone is actually asking for a follow-up question from your second session, your last session, if that's okay. If not, we can proceed to other. Okay. So this question being, if we are submitting a thorough FL 157, should all factors be restated in the declaration or just certain ones?
Well, one of the things that if you think a factor is more important than another factor, there's no reason why not highlight it and go into more detail in your declaration. List the factor in your 157, but go into more detail in your declaration supporting your RFO.
Right.
Keep in mind, people remember what they read first and last. So if you have something that's really important that you want a judge to read, I did a pleading seminar one time and I said, I understand that your clients want to pontificate on everything that's wrong in their life. So if you'll just give me the most important stuff in the beginning of your declaration and then start with, my client wants the court to know, then I know I can stop reading at that point in time because you're telling me that that that's not legally relevant, but then you've met your client's need of saying things. Just don't say, he cheated on me, because we know that that's not acceptable. But, sometimes they just need to think that the court listened. And even though I shouldn't say I stopped reading, because I didn't, I always read everything, but at least I know that that it's not legally relevant. If you say my client wants the court to know, then I know you understand that I understand it's not that relevant.
If there are no latches or enforcement is sought over a decade later, what does the court do about lack of evidence? Is it just testimonial?
Yes. And that is a problem, because you read these cases where the person has waited 10 years and never made any attempt to collect, never made any, hey, you're not paying me, hey, you're not. These were really hard cases for me because the law is pretty clear. There are no latches to support the person. And the theory behind that is the person knows they have a support obligation. They know they haven't gone to modify it. They should know that if they don't pay it, they have interest on it. So therefore, I'm really sorry that this sits right here, but you got to pay it. I mean, there's been situations where there's 400, 500,000 in arrears based upon that particular scenario. Is it fair? No, but it's the law. Unless you can prove that the payee's conduct was so egregious, convincing them that they didn't have to pay, you can try that. That's the equitable estoppel argument. But no, support's due until it's paid, and interest accrues until it's paid. And it just, when you get a $400,000 judgment, the payment amount that you would have to make on that is to even pay the, you'd have to pay $3,333 a month just to cover the interest alone. So yeah, it becomes a huge problem.
Right. Another question here. What is the best way to have a permanent spousal support order modified if the recipient is totally disabled?
Well, there's an old case by the name of Baker, and one of the things that the client said in the Baker case was, I don't want to be tied to the dead carcass of my marriage. And I always thought that that was language that was very flowery and made some sense. But at some point in time, people need to understand that the support isn't going to go on forever unless you have a 60, 50-year marriage. At some point in time, the court is going to pull the plug on it because of a change of circumstance. So, Those are the hard cases where you have somebody who's truly disabled. I mean, and especially if they've been declared disabled by the state or the federal government, like those are much harder cases to overcome a disability than the ones who just go to a doctor and the doctor says, oh, they're disabled for life. Those were very questionable, those types of declarations that I got. So yeah, the cases where the party's disabled are much more difficult to overcome.
Right. Let's see. Looks like I think this is a follow-up regarding the retiree with
Okay.
the authorship.
Sure.
Is my client required to take a certain percentage from his pension as a distribution annually?
Well, it depends on the judge. I would not make somebody you have to take a minimum distribution from your pension at age 73. So at 73, yes, it's going to be counted as income because you have to take it. But before that, at a 20-year marriage, I'm not going to make somebody take a distribution just to continue to pay support. There's another judge who probably would. So a lot of it depends on, do you know your judge? Um, you know, and that's a fairness argument. It's not fair that I assume some of the pension that or the retirement that he or she's asking the other person to take was given to them as a property distribution. Even though you didn't get a white waiver at the time of the judgment, the argument is it's really unfair that I have to invade my retirement accounts to continue to pay support. But it could happen. Especially if the judge believes the person is disabled and the judge believes that the support of that person is going to fall to the public, that's another consideration.
All right. I believe I did request the citation for this one. I think I mentioned it when we previous went over. Just want to confirm. I have someone is asking regarding the previous question regarding obliger not being served. Could you give us the citation in regards to marriage of Gorham?
Yes.
And then however that is spelt as well.
Gorham.
All right. Perfect. And the next question being, is it correct that an abstract of support only clouds title, not act as a lien against the property, and a LIS pendants not available?
No.
Not available post judgment?
No. A lis pendens is a dispute over the property. And when you have arrears and you're just owed a judgment, you don't have a dispute over the property. One of the things, while we're here on lis pendens, one of the things you need to know about a lis pendens is you should never record a lis pendens unless on a piece of property in a family law action, unless you have identified the property in the petition or the response. Because you as a lawyer can be liable for recording an inappropriate lis pendens. And if you don't have the property description in your petition or response, that could get you in trouble. So remember to do that. But a lis pendens isn't available for arrears. An abstract of judgment puts a cloud on the title. If one of the things, if you want to go forward and get a lien or, foreclose on property, I would highly suggest you get a lawyer who knows how to do that because it's really difficult.
All right, let's see. Holly is asking, what are some examples of such egregious behavior to justify an estoppel defense?
Equitable estoppel. Okay, the one I thought about is, let's say that this person is not in arrears, but arrears. And the person actively goes and causes the person to lose their job so that they don't have the funds to pay. You got unclean hands on one side and equitable estoppel on the other. So if I'm trying to think of another example where equitable estoppel. might play in. I actually can't think of one, but I'll put it on my list of things, and if I can think of one, I'll send it out.
Right, let's see. What's the best argument to overcome a 100% disabled veteran finding? Can income still be imputed?
They're 100% disabled by the Veterans Administration. Is that what we're talking about? Because even if you're 100% disabled from the Veterans Administration, you can work. There's plenty of people out there getting 100% of disability and working full time. It's going to be a harder call. And a lot of it depends on what is the disability. You know, are they in a wheelchair and a quadriplegic? Then you're going to have a really hard time. Is it PTSD and they mentally can't work? Maybe, you know, they have a hard time. So a lot of it depends on what the disability is. There's plenty of people with disabilities I had a client one time is 100% disabled from the military, 100% disabled from the civil service, and then working full time at a casino. So it does, I mean, they do are able to work. One of the things you might consider in that is an independent medical exam. So your client pays for an independent medical exam that looks at the medical records from the organization that has declared them disabled, and then they do their own examination and provide a report to the court. It's an uphill battle when you have somebody who's been declared 100% disabled by a government agency.
Can you explain?
Go ahead.
Sorry about that. Can you explain what specific language is needed in a white waiver?
Something to the effect of the parties agree that the division of the petitioner's pension, that the interest received by each party will no longer be available for support at any later date.
All right. Okay, so recently I successfully obtained an order expunging 5 lease pendants because opposing parties' petition merely indicated the boilerplate language rather than identifying each property at issue.
That's right. That's what'll happen.
All right, and let's see. If government determines a party is disabled, is the family court bound by that finding, or do they have to establish their own finding?
I don't think a family court is bound by that finding, but you would need some pretty strong evidence to overcome that. I think one of the things, judges who work in military towns understand this a little bit better than judges who don't, because we all know that there are people who work full-time even though they're disabled. But the burden is on you to overcome that finding by the government agency. And like I said, the IME is probably your best tool. Or if you know that the person is working under the table, get a private investigator and go at it that way. Then you have the credibility issue established. And so, because that happened, you know, sometimes too, where they working under the table.
Okay, and then that looks like just one more question. Is Gorham a DCSS case?
Yes.
186 Cal, I guess.
Thank you.
Yeah. All right, so that does look like that's it for questions now. Commissioner Radican, do you have any closing remarks or comments you'd like to make before we close this off?
I want to thank everybody for taking time to be here today. I really appreciate it. Hopefully you got some good tips to take away for your practice, and I want to thank the Beverly Hills Bar. I really enjoyed speaking. Thank you.
Perfect. This concludes today's presentation. Thank you so much again, Commissioner Radican, for an excellent presentation today, and thank you so much to our audience for joining us. Have a great evening, everybody.
You too. Bye-bye.